National Federation of Filipino American Associations, Organization of Chinese Americans, API Equality Northern California and Los Angeles, South Asian Americans Leading Together, the National Korean American Service and Education Consortium, and the Asian American Center for Advancing Justice, composed of the Asian Law Caucus in San Francisco, the Asian Pacific American Legal Center in Los Angeles, Asian American Justice Center in Washington, D.C., and the Asian American Institute in Chicago. This webinar will be recorded and posted online along with the PowerPoint for future reference. You will be able to find it on tinyurl.com/advancingjustice-DACA. And now we will introduce the panelists who will be speaking at today's webinar. My name is May, and I am a Chinese undocumented dreamer from UC Berkeley, and I currently am studying integrative biology and theater and performance studies as a double major. I am part of ASPIRE, Asian Students Promoting Immigrant Rights Through Education, which is an undocumented Asian youth advocacy group housed at Asian Law Caucus in San Francisco. Anthony is a Filipino-American dreamer from Los Angeles, California. He currently interns at the Asian Pacific American Legal Center doing deferred action and immigrant rights work. He is a member of Dream Team LA, and community-based organization that fights for immigrant rights and other social justice issues. Joyce is a supervising attorney for the Immigration and Citizenship Project at the Asian Pacific American Legal Service. Prior to joining APALC, Joyce was a supervisory asylum officer with the U.S. Citizenship and Immigration Services. Joyce graduated from the University of Southern California and received her JD from University of California Davis School of Law. Adrian is currently an organizer with the Inland Empire Immigrant Youth Coalition, an organization that challenges the criminalization of immigrant communities which promote immigrant rights. He also interns at the Loma Linda Broadcasting Network and is interested in documentary film and television. Next slide, please.
Can you all see the screen yet? May, can you see the screen?
Not yet.
Not yet. Okay. 1 second, folks. I can't press the play key. Chris, can you play? Can you press it for me, please? It's. Okay. Okay. There you go. Thank you.
Alrighty. Sorry about that, folks. Let's just get started again. So this is just a media disclaimer. This webinar is not intended for the media, and media is welcome to listen but is prohibited from quoting participants, presenters, as well as the attendees of this webinar. For follow-up questions, please contact Ratchani at APALC Communications Director, 213-241-0227. Next slide, please. So the agenda for today's webinar, we're going to first talk about the history of deferred action for childhood arrivals, the advocacy surrounding that. And next we will have Joyce talk about what is the deferred action for childhood arrivals, eligibility requirements, application process, and then we will have the time to ask questions after that. After Joyce will be talking, we will start sharing some dreamer stories and why we should all apply for DACA. And lastly, we will give you some resources. Now, here are the instructions for the questions. If any of the participants or attendees would like to ask a question, please write your questions in the questions box, and we will get to them at the after Joyce's part about DACA. There are already some questions up here, and hopefully most of them will be answered. If you have any more, please just keep asking questions and we will answer them at that time. Next slide.
So please.
All right, so go ahead.
Please answer the poll, folks. Thank you. I'm going to close the poll in about 10 seconds. So I'm going to close it in 5 seconds. 4, 3, 2, 1. The poll is now closed. So hello everybody, my name is Anthony. I'm a dreamer from LA. So I'll be talking about the history of deferred action. So it really started when the DREAM Act failed in 2010. So it failed by 5 votes in the Senate. So those 5 votes could have been a Democratic vote, but they chose to abstain or be absent. So kind of like giving a light to that, that the blame for the DREAM Act isn't necessarily just for the Republicans, it's both parties. So we need to make both parties accountable for their actions. So around that time, it was a very sad time for the immigrant community because the failure of the DREAM Act kind of like created this kind of like created this very negative energy in our community. So in early 2011, a group of folks kind of started having a discussion about the status of the immigrant community in the U.S., kind of analyzing the different negative policies that are being implemented, like SB 1070 and different local legislations, or even secure communities, which is a national policy that really affects the immigrant community, not just the Latino community, but every single immigrant community, because it does criminalize a lot of our families and a lot of our friends. So in early 2011, this woman named Nady Dominguez, she's a dreamer from Los Angeles, kind of proposed this idea of deferred action or administrative relief, which basically would have provided relief for undocumented youth and provide work permit. So she pitched this idea to other dreamers and to other legal folks to kind of like even see if it's a feasible avenue to go through. So she basically did a lot of the legal research and like brought people together and made sure that like every single part of it was covered. So through United We Dream, excuse me, through United We Dream, a national immigrant youth network, the administrative relief campaign was made a national campaign, which basically provides a work authorization for undocumented youth and holds deportation or prevents deportation of undocumented youth, as well as the possibility of traveling outside the country, which is known as advanced parole. So a lot of allies and a lot of dreamers really took a risk when the campaign launched by doing a lot of civil disobedience, a lot of actions, really standing up for what they believed in. Just because they knew that the immigration system was so broken that there was no other way really to kind of like make our voices heard other than like showing action and visibility that we're here, we're undocumented, we're not going to leave, this is our home country. So it was a really good collaboration between allies and dreamers. So for example, the Wilshire Five were a lot of allies who got arrested standing up for what they believed in, which is like trying to get deferred action kind of get rolling. So these are some pictures of the different action or administrative relief campaign actions. So you see people doing civil disobedience, sit-ins, and protests, and even just doing like rallies to really like show visibility of our community. So in early or late 2011 and early 2012, people noticed that the the campaign wasn't really catching on because I guess it was too a little too complicated for folks to understand, or it wasn't a catchy tag. So a group of folks decided to kind of like, I guess, make it simpler, accessible, and make it very simple for a lot of people to understand. So once they do understand the campaign, they can explain it to other folks and educate them that this is the new campaign, the Right to Dream campaign, which launched in early 2012, which is basically the same thing as the Administrative Relief campaign, but simpler and a lot more accessible. So these are the core values of the Right to Dream campaign, which is like known as the Declaration of Dreams, which is basically the right to live our lives without fear, the right to live with our families, the right to live with our loved ones, the right to move freely, and the right for an education, the right to give back to our communities, the right to really build a strong, sustainable economy, and basically the right to fulfill our dreams. So on June 15th, President Obama announced Deferred Action for childhood arrivals, which basically is the Right to Dream campaign and action, basically. So a couple of weeks before that, a group of dreamers and lawyers went to the White House to meet and kind of like give this letter signed by 96 law school professors who focus on immigration, saying that the president or the administration had the right to provide administrative relief to undocumented youth. So it was really basically the answer they were looking for, because before in the other meetings that had happened, they were saying, oh, we don't know what if the president has that right to do to provide that relief. Now this letter basically says, yes, you do have the right to do that relief. So it was a really big step for our community, because I think it's one of the critical point where it really helped move the campaign was when it was backed up by like law professors, and this was made possible by like the creativity, the persistence, and the courage of dreamers, not just here in California but all over the country, because it is a national issue. We do have dreamers who do different protests in Arizona, Florida, New York, and so on. So this victory, Deferred Action, was made possible by dreamers, and it is for dreamers, but it's for our families and for our community as well. But this is only like a bandage on a big wound. This does not mean that we're going to stop with just Deferred Action. Of course, we're going to push for the DREAM Act, and of course, we're going to push for humane immigration reform, something that makes sense to our communities and to our families. Just because when the DREAM Act passes, we're not going to stop there, because we want something for our families and other folks too, because not everybody qualifies for the DREAM Act. I've had friends who age out of the qualification, who've been in the movement for a long time, and it's not fair that they don't get to reap the benefits of something they worked for a long time. So thank you for that. We'll move on to another poll, so if folks can please answer this next one. I'll be closing the polls in 10 seconds, folks. Five, 4, 3, 2, 1. The polls are now closed. I'd like to give back the mic to May, please.
Alrighty. So next we will have Joyce, our attorney, talk about DACA. It's what you can expect from the application, the requirements, and any eligibility. So Joyce.
Thank you. Good evening, everyone. Thank you so much for taking the time to listen to this webinar today. And what I'm going to go through is I'm going to go ahead and go through some of the eligibility requirements and also talk about some of the issues with the deferred action process, and also just talk about some tips when you're preparing for the application themselves. So we'll go ahead and get started. Next slide, please. Okay. Now going back to the DHS memorandum and the announcement of President Obama on June 15, 2012, some of the key points is what deferred action is. And what it is that it's not an executive order, but rather executive authority to defer removal. What the president has done is basically exercise discretion to defer removal for a certain class of immigrants who came to the United States as children. The approvals for deferred action are in 2-year increments. It does not confer lawful status, and it does not create a permanent pathway to legal status or to citizenship. Next slide, please. Some key benefits of the deferred action process is, number one, it does provide safety from deportation, and that's what deferred action is. So for the period of 2 years, immigration authorities will not be instituting immigration enforcement against folks who are approved for deferred action. The second key benefit is it also allows for employment authorization. So with an approval of a deferred action application, someone will also be approved for employment authorization, and they will be able to work. Next slide, please. Some additional benefits is it does also stop the accrual of unlawful presence. And what unlawful presence is, and that's a term in immigration law, and what that means is basically once someone turns the age of 18, and after that, every day that that person is here without lawful immigration status, they start accruing what's called unlawful presence. And where this matters is if someone who's accrued unlawful presence and who has now exited the United States and then tries to re-enter the United States, they would be barred from a period of ranging from 3 to 10 years. And so where we see this happen a lot is with folks who marry U.S. citizens and who may have entered the United States without inspection. And so what the deferred action process does is it will stop the clock on unlawful presence. For folks who are 15 and who have not reached the age of 18, the good thing is that they have not started to accrue unlawful presence. And so with an approval of deferred action, then they will be accruing this issue. But for folks who are over the age of 18, with the approval of deferred action, then it will stop the accrual of unlawful presence. Secondly, with the deferred action process, with the approval and with the employment authorization, you will also be able to apply for Social Security numbers. With your employment authorization card, after you receive that, then you'll be able to apply with the Social Security Administration for your own Social Security number. USCIS has also talked about the possibility of travel outside the United States. And the way that that process would be made possible is through what's called advanced parole. They have allowed that could be a possibility for some folks, and what we are advising is that while that may be true, it is an individual case-by-case basis. And for someone who's approved for deferred action who would like to travel abroad, we strongly recommend speaking to an immigration attorney first to assess any possible risk, because sometimes when someone travels outside the United States without a status and they try to enter, they may run into some risk and maybe have difficulty re-entering the U.S. But there is this definite possibility, and for some folks they will be able to access traveling outside the U.S. Additionally, we also believe that with deferred action that folks will be able to apply for driver's licenses, and that will be varied by state. For the state of California, for our callers who are calling in California, we do hope that DMV will issue their official position and that they will be granting driver's licenses to people who have approved deferred action. But for other folks outside of California, definitely check your state and definitely get plugged in with the advocacy groups out there to ensure that this is made possible, because that's another key benefit that a lot of the DREAMers will also need to have. And then finally, also economic stability. You know, with the employment authorization, with the Social Security number, with this ability to now use their education to get better paying jobs, etc., this starts the road to economic stability. And so that's kind of another additional benefit of the deferred action process. Next slide, please. Some important things I did want to hone in on and remind folks is that the intent intent of the program is to provide deferred action to eligible undocumented youth who came to the United States as children. I know that there has been a lot of news out there, also a lot of fear, and what people are thinking that this is really just kind of a ruse for the government to actually get people who are not without status. And so what I really want to emphasize and to follow what Anthony has presented earlier is that the deferred action that we see is really the result of the hard work of Dreamers across the nation and in getting this program through the administration. And so really the intent of the program is to provide relief. It is not an immigration enforcement program. However, the USCIS and ICE have identified priorities in which they would seek enforcement, but that the intent of the program really is not to enforce immigration policies against folks. And that also extends to family members and to legal guardians. So that's a really important piece of the information that I really did want to get out there to dispel any myths and any fear in the communities. Next slide, please. Some other things to remember when you're applying for the deferred action process, while all of these great things are true, there are no guarantees, and I know that there is a lot of discussion about what will happen with the election, etc. With this program, there is this ability that the program could change, it could end, and etc. So it's important to understand that this is a really great program. There are really no guarantees, and we won't really know much until a lot of other things happen, but we will still continue to push for reform and relief for everyone. It's important also when you do decide to apply for the deferred action process, it will be coming forward about your identity and also your immigration history. So it's important to get support from your family and your loved ones when you're going through this process, that you will be revealing yourselves and you will be coming forward to the immigration service. There will be potential vulnerability to immigration enforcement if also your case presents some kind of criminal, public safety, or national security risk. And we'll talk more about that in later slides about some of the issues to watch out for. Okay, next slide, please. At the end of the day, again, going back, is really the decision to apply requires careful deliberation and support by family members, by loved ones, and also fellow dreamers out there. We really encourage folks to get connected and to get the support they need as they go through this process. This process is very long and it can be time consuming, and so it's really important, and we want to emphasize to folks to get the support that they need. And also to remind everyone that while this deferred action relief is truly a great victory, it is just a first step for a more permanent solution for everyone, for all of our families and for all of our fellow immigrant communities. Okay, next slide. Okay. I did want to spend some time to talk a little bit about the unauthorized practice of immigration law. And the reason for this is because it's really important, and in the past we've seen, unfortunately, with other immigration programs, that people will take this immigration benefit and use it to their advantage and to defraud immigrant communities. And so what I wanted to talk about in these really briefly is just talk about the unauthorized practice of immigration law. Only licensed attorneys and BIA accredited representatives are authorized to practice immigration law. And what that means is that only licensed attorneys and BIA accredited representatives can give legal advice. Only they can explain immigration options, and only they can really communicate with USCIS on your behalf. So it's important to be aware of any notaries or notarios, preparers, so-called immigration experts. Those folks are not authorized to practice immigration law. So it's really important to make sure that you are understanding if you're seeing a lot of ads or a lot of people are approaching college campuses, etc., saying that they could provide assistance. Remember that only licensed attorneys and only BIA accredited representatives can provide assistance in immigration law. Next slide, please. Some common scams that we've seen in past immigration histories, a lot of folks who these preparers or so-called immigration experts will say that they can expedite the process, that they have some way to make things go faster, or that they can get also all of the family members' status and not just yourself. So it's important to be really wary of that. and also be informed about what information is out there. You know, the USCIS website has all of the information about who is eligible and who can provide immigration assistance. So it's important to be educated. It's important to get connected with dreamer groups and trusted community-based organizations. And please be wary of any type of, you know, false claims or, you know, things that sound too good to be true. This is a problem, and we have seen it here in LA of folks, you know, with ads, misleading ads, and people trying to charge, you know, exorbitant amounts of money and trying to make a profit off of this program. So we really want to stress that and emphasize that. Next slide, please. Okay, so now for this section, I did want to go ahead and go over the eligibility requirements for the deferred action process. And here are the requirements. You must be under the age of 31 as of June 15, 2012. You must have come to the United States before reaching your 16th birthday. Continuously resided in the U.S. since June 15, 2007 up to the present time. You must also be physically present on June 15 and at the time of making the request to USCIS. You must have entered without inspection before June 15, 2012, or your lawful immigration status expired as of June 15, 2012. You must be currently in school, be a high school graduate, a certificate, or have a certificate of completion from high school, GED, or be an honorably discharged veteran of the U.S. Armed Forces. You must not have been convicted of a felony offense, a significant misdemeanor offense, 3 or more misdemeanors, and do not otherwise pose a threat to national security or public safety. You must be at the time at least 15 years old at the time that you file. If you are in removal proceedings or have received a final removal order, voluntary departure order, and you are not in detention, you can be younger than the age of 15. Next slide, please. Okay, now where do you apply for deferred action? You will apply with USCIS, and that's the United States Citizenship and Immigration Services. And you will apply through USCIS if you have never been placed in removal proceedings, are currently in removal proceedings, received a final order or a voluntary departure order. If you are in immigration detention, they are advising folks to inform your detention officer or contact the ICE Office of the Public Advocate. And the number and the email address is listed there. So if you are in detention, you will not apply through USCIS. What they are advising folks is to go ahead and inform your detention officer or contact the ICE office. Next slide, please. Okay. Now the application process is actually quite intensive. There are several things that you'll need to have in order to apply for deferred action. There is a required 3 forms at least, and a 4th if you opt to do e-notification. But I'll go through the application process here. You will file a G1145, and that's the optional e-notification. And that's if you would like to receive an email or a text message from USCIS that they have received your application. So that's an optional form, and if you like to use your text or your email, then USCIS can contact you in that form. But it is optional. The next 3 are the required forms. So the I-821D, which is the Deferred Action for Childhood Arrivals, and that is a new form that they created just for this process. The second form is the I-765 Employment Authorization Application, and that form is a form that is generally used for anybody that's trying to apply for employment authorization, so they did not create a specific form for deferred action. And the third form is the I-765 worksheet, which is new and which they created for the deferred action process. And so those are the 3 required application forms. You'll also need to submit a fee for $465, and that fee is made by a check or a money order to the U.S. Department of Homeland Security. We do suggest a cover letter if you're going to be filing this on your own. A cover letter is a good way to inform USCIS who you are and also the documents that you're going to be submitting. So along with the forms, you will need to submit supporting documentation that you are eligible for the relief. And so it can be a very lengthy, kind of a lot of documents that you'll be submitting. So a cover letter is nice because it acts like a roadmap to the USCIS officer on the different things that you're submitting. And but again, that is optional. We also suggest doing certified mail with return receipt just so that you also have proof that the USCIS office has received your application. And we also recommend making a copy for yourself. Okay, Next slide, please. I mentioned the fee, and the fee is $465. Unfortunately, they did not approve a fee waiver for the fees, but they did allow for a fee exemption in 3 limited circumstances, and they are listed on this slide. The first is, and you have to either fill one of these criteria in order to get the fee exemption. You must be either under the age of 18, homeless, in foster care, or under 18 years of age, and otherwise lacking any parental or other familial support. And your income must be less than 150% of the U.S. poverty level. Or if you cannot care for yourself because you suffer from a serious chronic disability and your income is less than 150% of the U.S. poverty level, you may also be approved for the exemption. Or finally, if at the time of the request you've accumulated $25,000 or more in debt in the past 12 months as a result of unreimbursed medical expenses for yourself or an immediate family member, and your income is less than 150% of the U.S. poverty level, you may also be approved for the exemption. Next slide, please. Now, with the fee exemption process, you must be approved for the fee exemption before you apply for deferred action. So it will add a couple of months, I believe, to your application process. And I believe the projection is about 4 to 6 months processing time. And so if you are going to do the fee exemption, it might add a little bit more time to that as well. So the way that you would apply for a fee exemption is you will prepare a letter requesting the exemption with the supporting documents showing the criteria from the previous slide if you fit one of those eligibility requirements. And it must be signed by the person seeking the fee exemption. If the person is unable to sign, someone else can sign as long as there is an explanation, and the person must be a parent or a legal guardian. And once you submit all of those papers to USCIS, then they will go ahead and decide that. And if they do approve it, then they'll send you an approval letter. And what you'll do with the approval letter is you then attach the approval letter to your deferred action forms, and then you'll resubmit to USCIS. Next slide, please. Okay. And now I did want to talk more at length about the applications and kind of the process and all of the issues that are involved. And I included here a quote from the DHS memorandum FAQs that they issued back in June 15, 2012. Only those individuals who can prove through verifiable documentation that they meet these criteria will be eligible for deferred action. And so what that means is basically, in addition to the application forms, you'll need to provide documentation and that can be verified to see if it's correct, that you fit all of the eligibility criteria. Next slide, please. Some of the issues, and this is what the application process covers, is identity and age, entry and continuous residence, education, economic necessity for employment authorization, criminal issues, public safety, and also fraud. I'm having an echo. Okay, I'll try again. Okay, next slide, please. So for the first issue I want to talk about is identity and age. So with the deferred action process, you'll need to prove who you are, and through that, the way you do that is with your identification documents. And this is what they'll use to run the background check and make sure that you are eligible for the relief. So for identity and age, and these are just the examples that the USCIS had provided about what you can produce to prove who you are, and also that you are of the right age, meaning that you are under the age of 31 as of June 15, 2012, and also that you entered the United States under the age of 16. And so these are just examples of some of the documents. These are just examples. So the birth certificate with the photo ID, passport, national identity document from the country of origin, any other U.S. government immigration documents, so people who've had previous work authorization cards or military ID. They also allow for any school-issued form of identification, and so that's another important way to prove who you are as well. So those are just some of the examples of what USCIS will take. Next slide, please. Again, you'll have to prove entry and then continuous residence. So we have to prove that you entered the United States before the age of 16 and that you've been continuously residing in the United States from June 15, 2007 until June 15, 2012, and also to show that you're currently here at the time of filing, etc. And here are some of the examples that USCIS had listed. These are not exhaustive lists. They will take other types of evidence, but this is just an example of what you could show in order to prove these requirements. So like a passport, an I-94 for folks who came with inspection, who came with the type of visa, that's what an I-94 is. Immunization records or school records. For folks who did enter without inspection, who came as young children, those are going to be really strong evidence of entry, and also school records evidence of continuous residence from 2007 2012. And so the list goes on, and there are other things you can use as well, and we'll talk a little bit more about the types of evidence. They did also allow for affidavits, and we'll talk more about that in a couple other slides, but they did allow for affidavits to cover certain gaps in documentation on continuous presence and if you had any brief casual departures from the U.S. So those are just some examples of some of the things that can be useful when you're trying to prove your eligibility for these requirements. Next slide. Brief departures. Now, continuous residence, you do have to show that you've been here residing for the 5 years. They did allow for brief departures, and brief departures are okay and will not disrupt the continuous residence requirement. And this is what it should be. This is what they call and characterize as brief departures. It must have been before August 15, 2012. And it must have been a short, reasonably calculated trip to accomplish the purpose of the absence. It cannot be because of an order of exclusion, deportation, or removal, or be because of an order of voluntary departure, administrative grant of voluntary departure, and that the purpose or actions outside of the U.S. were not contrary to law. So for folks who've had some brief departures during the 5-year period, this is the things that you'll look at to see if those brief departures are going to be okay and will be all right for your continuous residence requirement. Also, I did want to add with that, you cannot travel outside the U.S. before USCIS has determined whether to defer action in your case. So it's really important that once you put in your application, do not leave the United States because they will deem that as an abandonment of your application. So I did also want to add that here as well. Next slide, please. Okay. Now for the education requirement, you must either be currently in school, have a high school diploma or certificate of completion, have a GED certificate, or be an honorably discharged veteran of the U.S. Armed Forces. And USCIS has also provided a lot more clarification on the school education requirement. Next slide, please. And this is how you look at the education requirements. This is what they define as currently in school. If you're in like a public or private elementary school, junior high, middle school, high school, or secondary school, an education, literacy, or career training program that is designed to lead to placement in post-secondary education, job training, or employment, and where you are working towards such placement, or an education program assisting students in obtaining a regular high school diploma or its recognized equivalent under state law. Essentially, we get some questions from folks like with people who are maybe in ESL programs or maybe taking community courses for their GED. What the key is looking at if your program isn't a public or private elementary school, the first bullet is to really connect your program and that how it's designed to lead to placement into a post-secondary education, job training, or employment. So that's kind of how you would look at the kind of education that you are in and seeing whether or not it would qualify. Next slide, please. Okay, actually, can you go back to the previous slide? Okay, so just to add to that, so essentially like for the second and the third bullet, So most, college programs, community colleges, etc., those will all fit into the, the second bullet. And where it might get a little bit more complex is, again, those other kinds of courses like ESL courses, maybe vocational training. But really what the key is that you will need to connect it and make sure that it is leading you to either some kind of post-secondary education or job training. There is a lot more clarification on that issue, and I'm not going to go into depth more on the education requirements here because of the time. But if there are any other questions on that offline, we're happy to entertain that. But there is a lot more information on the USCIS website regarding the education requirements. Okay, next slide. Now for economic necessity, with the I-2A21D, which is the Deferred Action application, you will also apply for employment authorization through the I-765. And what that is for people who are going to be approved for Deferred Action, in order to get the employment authorization, you must show what they call economic necessity. And this is what that means is basically you need to show that you need to have work authorization. And the way that you demonstrate that is this created USCIS had created this other form, which is the I-765 worksheet. And that's where you will demonstrate your economic necessity. The kinds of information that will go onto that worksheet is if they're going to ask you to capture your annual income, your annual expenses, and also your assets. And from that, that's how they will determine your economic necessity. Now, for folks who have not yet seen the form, or if you have seen the form, when you record your annual income, your expenses, and your assets, those are going to be just pretty much numbers. And at the bottom of that form is an additional space to include any supporting information. And so what we've been telling our folks is we really highly encourage folks to go ahead and put in some more information to give life to the numbers that you're reporting. So if your economic situation includes a very low-paying part-time job, if you are being supported by your parents, or if you have only one parent that is working, etc., or you have children that you are supporting, we definitely encourage folks to put meaning behind those numbers and to demonstrate the economic necessity and to show how employment authorization will improve your financial situation. And so that's what the purpose is on the I-765 worksheet. And in order to get employment authorization, you will need to prepare this form with the I-765, and that's what they're getting at, and that's why you need to fill out that form. Okay. Next slide, please. I'm going to spend some time now to talk about the criminal issues. This is another area where we do get a lot of questions about how all of this will play out. So we'll go ahead and discuss a little bit here about the different types of criminal issues that will come up. Next slide. So in order to be eligible for deferred action, you cannot have been convicted of a felony, and a felony is a federal, state, or local criminal offense punishable by imprisonment for a term exceeding 1 year. Next slide, please. And USCIS has also carved out this other, besides felonies, also if you've been convicted of a significant misdemeanor. And there is a lot of language on the FAQs about significant misdemeanor, but essentially, if you've been convicted of a domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug distribution or trafficking, or DUI, that is going to be considered a significant misdemeanor. And according to USCIS, you would not be eligible for deferred action. Another way that they have defined significant misdemeanor is also by how much time in custody that you're sentenced to. So here, if you've been sentenced to time in custody of more than 90 days, that could also that would constitute also a significant misdemeanor if it's not one of those crimes listed in the first bullet. And the sentence must involve time to be served in custody and does not include a suspended sentence. And so, for folks, I should have said a little bit earlier before we delved into the criminal issues, but we definitely encourage and highly recommend you need to speak to an immigration attorney, an experienced immigration attorney before applying for deferred action if you have any issues, any past criminal history, any encounters with law enforcement, because it's important to understand what that might play into your deferred action request, and we really want folks to make sure that they talk to the right people when they're deciding whether to apply for deferred action. Okay, next slide. Another thing, a disqualifier will also be on misdemeanors. So what they've said is 3 or more, so multiple misdemeanors, so no more than 3. And a misdemeanor is defined by federal law as a maximum term of imprisonment authorized as 1 year or less, but greater than 5 days. And so what they will count, and towards the count for misdemeanors, is it is not an offense of domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug distribution or trafficking, or DUI, and one in which the individual was sentenced to time in custody of 90 days or less. So if you have a crime and it's not one of those offenses that were listed and you were sentenced to a time in custody of 90 days or less, it could be a misdemeanor that could be counted towards evaluation of your deferred action case. Next slide, please. So if you have any of those misdemeanors, you can't have more than 3. And what they have said for minor traffic offenses, like driving without a license, they will not count that as a misdemeanor. So I know for a lot of the dreamers out there that is a common issue, is the driving without a license. And so what USCIS has said is that will not be counted towards the misdemeanor, but they will look at the totality of the circumstances approach. And what I wanted to expand on that, what that means is basically what they've said is that you can't have more than 3, you would definitely not be eligible for deferred action. But if you have maybe 1 or 2, they could still deny your deferred action application because they're going to look at your whole case. And it will be decided on discretion case by case. And so while maybe someone who may fulfill all of the eligibility requirements and may have 1 maybe misdemeanor or maybe 2, they could still be denied because of this totality of the circumstances approach. So that's another thing important to clarify with folks is that USCIS has reserved the right to use discretion, and so even if someone is eligible, they could still be denied because of this. Next slide, please. Expungement convictions and juvenile convictions, what they've said is it's not automatic disqualifiers. Again, it's going to be a case-by-case adjudication and also going with the totality of the circumstances approach. So looking at someone's entire record when deciding whether to grant someone deferred action. Next slide. And also, in addition to those criminal issues, there is also this public safety national security threat. So if a deferred action application presents any of these kinds of indicators, then they will also deny the case and they will also be found ineligible. So if there is something in the case that presents some kind of gang activity, any terrorist activities, or other activities that the person may have been involved in that might be deemed as a public safety or national security threat, that person will also be found ineligible for deferred action. And if you look at the 821D for folks who've seen the application, they do ask a series of questions, and that's what they're trying to get at to see if this applicant presents any of these issues. Next slide. Now, for a lot of folks, people do have criminal issues, and I think that it's really important to make sure that you get all of the information available so you can have it reviewed by an immigration attorney. And so these are our tips. If anybody has any kind of criminal background, any law enforcement encounter, try to obtain all of your court dispositions and your criminal records in your case. We suggest getting an FBI background check, and that's for folks, in all of the other states. And what this FBI background check will do is it will give you your criminal history. And we suggest when you obtain your FBI background check, you state that the reason for getting that is just for your own records. So we highly recommend folks going out there and getting that so they understand what is in their background. And also for the folks that who may not be found, are eligible for the relief, but may have some, a couple of misdemeanors or maybe something from a juvenile conviction or something like that. What we are telling folks is to also gather evidence on any positive equities in your case. So if it is going to be this totality of the circumstances approach, if it's going to be this balancing of negative and positive, what we're telling people is to definitely start identifying what are the good things about your case. If it was something that happened a very long time ago, what are the positive things you've done since? If you finished school, if you're raising a family, you've become active in your community, et cetera, et cetera. We're definitely letting folks know that this is a good, probably key evidence in terms of trying to tilt your case into a positive adjudication. So definitely start identifying that and documenting where you could get that information to present. And again, I can't emphasize this enough, definitely speak to an experienced immigration attorney prior to submitting your case for deferred action. Okay, next slide. Okay, and then I did want to add here a section here about fraud, and that's because this is something that USCIS has emphasized to stakeholders and through their community education materials. Anyone who tries to gain deferred action through fraud or misrepresentation, failing to disclose facts, they have said that they will treat this case, that person, as an immigration enforcement priority. So it's very important that you get the right advice from folks, that you seek assistance and guidance from trusted folks, and that you also understand the forms, and that you're thoroughly familiar with the information that is being requested, and that you're comfortable with the information that's going to be put on there. So we really suggest getting really familiar with the application, making sure you're informed, and also talking to trusted folks before submitting an application because of this fraud immigration priority that USCIS has identified. Next slide, please. Okay, so for documentation, I did want to add a section here. It talked about the eligibility requirements, but I did want to talk about just some of the things, and we talked a little bit briefly about some of the evidence or items that USCIS has said they would take in order to prove the eligibility requirements. But I did want to talk a little bit more about that, or expand for a minute. For the use of circumstantial evidence, and circumstantial evidence means basically evidence that's not direct evidence of something that's true. It's rather just things that will tend to show that something is true. And what USCIS has said is that they will accept circumstantial evidence to show proof of physical presence on June 15, 2012. So for example, if you have bank records that show transactions on June 11th or June 14th, but maybe not on June 15th, that would be an example of circumstantial evidence. They will also take circumstantial evidence for entry before age 16. So, immunization records, school records, etc. Also, anything on the 5-year continuous residence to fill in gaps, they will take circumstantial evidence. And also any brief travel outside the United States during the 5 years, during the 2007 to 2012 period. Next slide, please. Now, where you cannot use circumstantial evidence and where they will require direct evidence is to show the proof of age, so the age of 31 on June 15, 2012. So you will need to produce some kind of identification document to prove that. And also on the education requirement, so you'll need to show proof that either you are currently in school, or that you are received your high school diploma, your GED, etc. So they won't take circumstantial evidence in those situations, but will require direct evidence. Next slide. And then on affidavits, we do get questions often about letters and things like that people have asked it would be useful. Now, what USCIS has said for affidavits, they've said that affidavits by itself would be insufficient to prove the eligibility requirements, and they've only limited the use of affidavits in certain circumstances. So only to show a gap in the documentation on the 5-year continuous residence requirement, or on the or the documentation in regards to brief, casual, innocent departures. And then you will also need 2 or more affidavits. And what an affidavit is basically it is a statement that will be sworn to, so like before a notary public. And that's what an affidavit is, and it will only be used in those two limited circumstances. So for example, a common case that we see is if someone may have a gap in time, if they took a break from school, had to take 2 semesters off, for whatever reason, and they don't have documentation to show that they were here for maybe a 9-month period, then an affidavit, 2 affidavits would be acceptable to show that they were here. Next slide, please. And what the affidavit should be, it should be by individuals who have direct personal knowledge of the events and circumstances. So going back to the example of the person that might have like a 9-month gap, the person who should do the affidavit is someone who saw that person during that 9-month gap and someone that saw them pretty regularly. So for example, like it could be an employer, maybe it was like a place where you had an internship, or a church, other kind of volunteer. It could also be family members. They did not limit it to not just those individuals, but it could be a family member. Basically, it just can't be yourself, though, that's going to be affirming the gap in the time. But make sure it's specific and detailed. So it's not enough to say that I'm this person's neighbor and I saw them. You really have to be specific and detailed and point to the frequency and the specific timing gap, specific times that they saw you, etc. Okay, and it will be certified under oath, and you'll do that through a notary public. Okay, next slide, please. And then just some complex issues or issues that we've identified through our work is one is that comes up pretty often, and we're hoping to get clarification from USCIS very soon on this particular issue, but the fraudulent use of Social Security numbers. We know that for many Dreamers that was a reality. In order to survive, many folks had to resort to using a fraudulent Social Security number in order to obtain employment. USCIS has said in calls with stakeholders that they are not interested in prosecuting folks who use the fake social just to work. However, where it gets a little bit complex is because the way that the forms are written. On the I-821D, the way that they worded Social Security numbers is different than the way they worded it on the I-765, which is the employment authorization document. And so it's really important. We're really hoping to get clarification on that soon. But if you had used a fake Social Security number in the past, we definitely recommend talking to an immigration attorney or BIA accredited rep just about the implications and how best to answer that question on the forms. Again, also criminal issues, if you have any law enforcement encounters, definitely could present some complexity in your deferred action case. Any brief departures in the continuous presence requirement, because again, it must be brief, innocent, and all of that. So there is certain criteria in order for CIS to find that you didn't disrupt the continuous presence requirement, and so that might add some complexity to your case. Also, if you have any documentary gaps, again, the success of a deferred action case is going to be key on the documentation. So if you have any gaps on certain eligibility criteria, that could present kind of a complex issue, and you need to have hopefully someone that can help think it through with you and help you get there. Also, the fee exemption eligibility, that as well will require a lot of documents, and it also adds some time to the processing. So that's also something to think about. And also any other issues that you want to think through before submitting application for deferred action. The forms are quite dense, and so if there's anything in your immigration history and your past that you really want to think through with someone, definitely identify those issues and definitely get plugged in with trusted folks. Okay, next slide, please. Now, for after filing, and we at APOC have recently just received some of our first receipts, but this is the process after you file all of your forms with USCIS. When you file it with USCIS, you will get a receipt, and the receipt will say that they received the case, and also will your receipt for the processing fees that you submitted. And so that's what will happen initially after you file, and that's about, I would say, maybe 2 to 3 weeks. That's from our experience, our brief experience with the forms now. And after that, they are going to issue an appointment for biometrics. And so USCIS will send an appointment for the applicant to go get biometrics. And what biometrics means is that you're going to get your fingerprints done by electronic filing. And what that means is they were going to use those fingerprints to run the criminal and background checks. So that's what the biometrics process is, and the USCIS will designate where you should go for that as well. There will also be, after that process, if your application is complete, then they can issue either the decision, which could be the approval or denial, or they might issue what's called the request for evidence. And the request for evidence will be if you are lacking something in your application. If there's some documents that you're missing, if you haven't proven that you entered before the age of 16, or you haven't proved your continuous presence, they will provide an opportunity for you to present additional evidence to cure that. So that's what the request for evidence would be. If you don't get your decision yet, they will do an RFE, request for evidence. And with that, you should prepare your response to an RFE with that, and then through that, you'll get your decision. The decision will either be a denial or an approval. For the denials, what they have said is for folks who don't pose any criminal issue, public safety, national security, then the case would just be denied, and that would be it. And they've also, I believe, have said that they would also allow folks to refile again, paying another fee. So if you think that you want to take another chance and apply again, that they will allow that as well. If you are approved, you will be approved, and you'll be approved for 2 years, and you will get the deferred action approval, and you'll also get your work authorization card, and that would be for the 2-year period. There is no appeals of any of those decisions, so it's important to note, and unlike other immigration forms of relief, there is no appeals process. And next one, and I think that brings me to the end of the section. Some final thoughts. Next slide. Some important tips. I can't emphasize enough that it's important to be prepared, so to be really familiar with the forms and all of the required documents. Preparation will be key to a successful application. Also, to be organized. It's important to organize the documents that you're going to be submitting. For some folks, it might be really simple and a thin application with just a few supporting docs, or it could be quite voluminous. So it's important to be organized, and it's important to identify documents that are helpful for your case. So if you have a piece like a phone bill but doesn't have your name on it, or it doesn't have a time period on it, doesn't have any dates, I mean, that's not going to be particularly helpful. But really being critical about your documents and really using them to that ability. Is it speaking to the actual eligibility requirement? Also is know when to speak to an immigration attorney or PIA accredited representative. So if you have any kind of criminal issues, any issues with the fake social security number, anything like that, definitely speak to someone and know that if you're hesitant about a certain thing about your form, definitely talk to someone. It's always best to be on the safe side. And then lastly, and probably most importantly, is to get involved with the DREAMer-led support groups in your area and nationally. This is a new process for everyone, not just for the advocates and for you all, but also for USCIS. And so we're all in it, and it's all really new. And so I can't stress enough how important it is for all of us to work together and be supportive of one another as we go through this process. And so with that, I will end my portion here, and thank you again for your time.
All right, thank you, Joyce. Now we will have some question and answer time. So we've been collecting the questions that people have been writing on the question box, and we've selected a few, so let us start with the first one. The first one is, do students need to be enrolled in school? What if they are already obtained their BA degree? And what do you put when you are currently in school, either high school or college?
Okay. If someone is currently in school, then the way that they should answer the question on the form is just to put in school. And they will also list on the form, it asks for the name and the city of where they're going to school, so they will list that as well. And if they're currently in school, the next question asks, I believe, the date of last attempt. Their degree.
All right. The second question is, in the application for employment authorization I-765, it asks for all of the Social Security numbers you have used. If I have used a fake Social Security to obtain employment before, should we put it in the application? If we don't, could that be considered as withholding info and possibly fraud?
Okay. Yes, thank you for that question, and that definitely highlights some of the complexities and the tension between the forms. Right now, I think the legal advocates, and these are some of the best immigration experts, I think everyone is pretty divided right now as to how to answer that question. And so there's different answers. If you talk to some advocates, some will say to put no valid Social Security number on the I-765. Some have been advising to go ahead and disclose, but also include a statement that it was only used for employment purposes. What I would say is because USCIS, I believe that there is some expectation that they will issue further guidance on this issue. And what I will say for now is to hold on to that and see if in the next couple of days USCIS becomes more definitive as to how to answer that question. And definitely keep in touch with the DREAMer groups, with all the organizations that are co-sponsoring, and we will get that information out to folks as soon as we get it. So I would say for now, just hold, and let's see what USCIS comes up with, and then hopefully we'll have a better answer for that. Thank you.
All right. The third question is, what are the options for students who live in states that are denying deferred action applicants things like driver's licenses? Can we go to other states and get a driver's license from there? This person lives in Arizona, and Jan Brewer, who is the governor, is trying to deny a driver's license to the applicants.
With that, I'd like actually to defer to Betty. Betty, are you on the line? Can you address that, and perhaps I can add?
Sure. This is Betty Hung at APOC. As Joyce mentioned earlier, whether a dreamer who obtains deferred action is eligible for a driver's license really depends on the laws of the state that they live in. In terms of whether to go to another state to obtain a driver's license, I think the main consideration there is that one would need to meet all the requirements of that state to obtain a driver's license. So it really depends on the particularities of that state. So it really is a case-by-case basis and analysis. There really is no general answer. So I would recommend that that one really look at the requirements in each state and what it would take to obtain a driver's license.
Okay. The next question is, wouldn't it be safer to flat out say that any DACA who has committed any kind of crime, minor or major, should not even bother with applying?
My answer to that is, I think that's a good question, and my answer is no. I don't think it should. I don't think it's that black and white. I think everybody's case is different. I think there's definite indicators in terms of like the definitions of significant misdemeanor, felony, but definitely for the borderline cases, or I really should speak to an immigration attorney who has experience and understands the definitions and will be able to advise properly. I think the relief is so important, and it would be great to be able to have people access the relief and just not, I don't think just flat out not applying is the answer. I think the answer is actually getting in touch with an experienced immigration attorney, a BIA accredited representative, and get a specific detailed case analysis.
All right. Next question. If a DACA applies and approved, the entire family is now exposed to the authorities to deport at any given time. Is it worth the risk to do this?
With that, what I would say is what's really, I think, great about the deferred action process is because it came from the DREAMers organizing efforts, that there is these provisions that say that the program is not intended to be an immigration enforcement program. It's intended to provide administrative relief to undocumented youth. And now with that, they have said, and it's specifically detailed in the USCIS questions, but information would not be provided to ICE, which is the immigration enforcement arm of the Department of Homeland Security. That information would not be given to them for enforcement purposes. They did state, though, however, if the case presents a criminal, national security, or public safety threat, that there would be a possibility and immigration enforcement could come into play. But for the folks that have family members and there is no issues like that, I would say that the provisions are there, and it's pretty clear that they're not interested in pursuing family members or legal guardians and the applicants themselves who don't pose those kinds of risks.
All right. Next question. Is DACA an executive order by the President or some sort of administration policy at DHS? And what are the consequences to DREAMers who receive deferred action if DACA is rescinded by a future administration?
DACA is not an executive order. It's an extension of executive authority. And what that means is basically what the administration has said is they're going to extend their prosecutorial discretion. And what that means is the government can identify priorities of cases that they want to enforce or prosecute. And what deferred action is an extension of that. They're choosing not to enforce immigration efforts against undocumented youth, people who have been approved for deferred action. To the second question, what will happen if it's canceled or rescinded by a next administration? What I would say is historically with immigration programs that once folks have been accessing relief, and especially in high numbers like this, it's often very hard for an administration to then take away a program. So I think it's been very few instances in history when that actually was true. So while I say that yes, that the program can be altered or kind of modified or maybe even canceled, like while that is true, and historically that's just hasn't been the case with other immigration programs. Anthony and Betty, if you would like to add, please, any other thoughts about that?
No comment.
Okay.
Covered it.
Okay. I need to make sure I included.
Okay. Next question is, how do I obtain an FBI background check?
Okay. If you go, and Anthony, if you could, and Betty could correct me if I'm wrong, but on our website, on APOC's website, we do have a toolkit, and the toolkit does provide instructions on how to get the FBI background check. And I won't go into here because it's actually quite detailed. There's a lot of little instructions on it, but I will direct people to the toolkit. And if you can't get to that, definitely send us an email online and we'll send it out to you. Is that okay?
Okay. And this is going to be the last question. After we get working permit, how do we apply for Social Security?
Okay. What you'll do is the Social Security Administration is the agency that actually issues the Social Security number. And so once you get your work permit, you'll get a card. And so with that, you'll go ahead and apply through a form to get your Social Security number.
All right. That is all the questions for now. You can, I guess, ask more questions, and we will see if we have more time at the end to answer some. But now let's move on to some personal stories from the DREAMers here on this webinar about why we are activists, why we think DACA is important, and what sort of our future holds. So I will go first. My name is May again, and I'm currently at UC Berkeley. So I first got involved when I was in my junior year of college. I was at a Asian Pacific Islander Issues Conference at Berkeley that's held every year, and one of the workshops that they were holding was an Aspire workshop about undocumented Asian people and Asian students. And so when I saw that poster saying that, I thought, wow, I finally found a place where I can get some help, because I felt before that I was like the only Asian person ever in the entire world who was undocumented. And so it was really great to see that there were other people who were also struggling, but also a place of support, especially for API DREAMers, just because there aren't a lot out there. We're not out there very much in the community, and people don't really think about Asian people as undocumented. So that's where I got started, and I've been involved ever since in San Francisco, and I've also worked at Berkeley as well to improve things like the California Dream Act and whatnot. So I think it's really important that specifically API people should go out there and do these advocacy things, because of the fact that we aren't seen as much in the media, and people don't know that there are Asian undocumented folks out there. But when you look at some of the statistics, almost half of the undocumented population are Asian. So I think it's really important that we get our stories and our faces out there and sort of combine forces to really make immigration reform happen. And so in terms of DACA, I pretty much applied the first day it came out with the help of the Asian Law Caucus. So the group that I joined, Aspire, is housed at the Asian Law Caucus in San Francisco, in close to Chinatown. And as soon as it came out, we were the first to apply, and our attorneys helped us, and I actually just got my letter to get my biometrics taken. So that's happening really fast. I'm looking forward to it, and I definitely think that there's a lot of fear in our community, but I also think that we should take this chance as an opportunity to be courageous and to step out and do things for us that are important. So yeah, next we will have Adrian. He's another dreamer, and he's going to share his story.
Yes, hello everyone. So my name is Adrian James. I was born in Thailand, in Bangkok, Thailand. I arrived in the United States at the age of 13. Oh, and really quick, can everyone hear me all right?
Yeah, we can hear you.
Okay, all right, great. So I'll continue. So it was after college, after the failure of the DREAM Act, when I first became involved in organizing. It was kind of a period when I was very distraught, and like I didn't have a lot of direction. That I was first introduced to the Inland Empire Immigrant Youth Coalition, which is an organization that's very involved in direct actions. So it was in the city of San Bernardino where I first received an email inviting me to a rally at San Bernardino to focus on this issue of, you know, undocumented youth. And as an undocumented person myself, I was excited, but also a little bit jaded about what would happen. I felt like I had seen a lot of these things before. I felt like I'd probably just show up and hear a lot of stories, and you know, a lot of teary-eyed stories, and everyone would leave, and the whole thing would pretty much end. So I got to San Bernardino, and that did happen. I did hear stories, personal stories being shared, and a lot of teary-eyed stories. But all of a sudden, before the end of the rally, it was announced that they were going to move this event from this little mini outdoor stadium thing to the street, where an act of civil disobedience was about to occur, where undocumented youth, some of them who were even minors, were about to be arrested, about to risk deportation, and in order to fight things like secure communities and 287G. And it was completely mind-blowing to me, completely shattering and shocking. I had no idea what to make of it. But it also created this moral crisis in me, this existential crisis, where I felt like, where I began to feel like I had to be involved from here on out. That I couldn't claim any of the benefits from the DREAM Act or anything else unless I became involved in my community. So that's how I got started. I got involved with the Inland Empire Immigrant Youth Coalition, which is also a part of the IYC, the Immigrant Youth Coalition in California in general, which is an affiliate of the National Immigrant Youth Alliance. So from there, for the first time ever, I developed a sense of community and empowerment. I felt empowered in being an undocumented person. That's something that I never had before. And it was in June, during the time when Deferred Action was first announced, that I really understood what it meant to have a community behind me. That was a time when NIA, the National Immigrant Youth Alliance, was holding civil disobedience sit-in protests across the country at Obama's Organizing for America offices. And I was called to participate in one of these things. I was very hesitant. I felt like I had so many questions, I didn't know what to expect, but I committed myself to going in there and getting it done. And I felt like I was making a big sacrifice, but what I didn't know was I was also gaining a whole lot, because for the first time ever, I really saw the community behind us. Behind all activists. There are people bringing food, there are people visiting, coming to support us, making sure that we were in good spirits, and it was truly amazing. And so, like, during that time, we all slept on the floor of the OFA offices, and in the morning of the June 15th, that's when Deferred Action was announced. And here we are today. Like, something came as a result of these direct actions. A great leap forward was, well, I should say, like, at least a step forward was taken for us undocumented folk. And I think that deferred action, applying for deferred action, can really empower undocumented people in a lot of ways by increasing one's powers. Having the ability to get to meetings easier, or contributing more and financially. So one should definitely apply for deferred action, and also remember how deferred action was won. It was through solidarity. It was through individuals sticking together. It was through courage, and that's all I have to say.
All right, thank you, Adrian. And now we will have Anthony speak about his experiences.
Hi, everybody. Thank you for, again, for going on this webinar. So my experience with organizing, so I was an organizer back in college, but but I really focused on other issues. So like I kind of started to like stray away from immigrant rights just because it was too personal. So when after I graduated, I was like, what am I gonna do with my life? I have a degree, but I can't do anything. So I was in this like 6-month depression of like what I'm gonna do, how I'm gonna find a job. So I applied for an internship through the UCLA Labor Center. It's called Dream Summer Internship Program. It's a national internship program for undocumented youth. So it basically placed me here at APOC, and it was an amazing experience. It still is. APOC has given me so much like space and like safe space for me to really grow as an undocumented person. And like really, the first thing that really like kind of empowered me is when on June 15th, when Obama announced Deferred Action, I was in front of the ICE office yelling undocumented and afraid with 150 undocumented youth. I'm like, I was scared in the beginning, but like it was the most empowering thing in the world, and really like meeting inspiring people in general, like the friends who I call family now as well. Like, they're very inspiring. The work that they've done, the work that they do, it's just knowing that these people are the ones who help bring Deferred Action to where it is right now. It's very like inspiring, and it just wants you just want to like go in there and like participate. When it comes to Deferred Action, I'm actually gonna apply soon. So tomorrow, Joyce is actually gonna like look over my application, and I'm actually not scared of what happens. So no matter who wins, I'm still gonna apply. Just because no matter who wins, we still need to mobilize our community and really advocate for the DREAM Act and for comprehensive immigration reform that makes sense. So for me, it doesn't really matter. Like I think Dreamers are like the best organizers in the world, and like it's whoever is gonna win the election, they're gonna have like some big obstacles to kind of like go over with Dreamers. We're not gonna stop doing anything. We're gonna move forward until we get equality for everybody, not just for Dreamers, but for everybody. So thank you. And a quick note, if y'all want to learn more about the immigrant youth movement, how it kind of started, like the different actions, there's actually a book called Undocumented and Afraid, Tam Tran, Cynthia Felix, and Immigrant Youth Movement. So it really talks about like the two pioneers of the immigrant youth movement and really how it kind of like transformed by these two women and like different actions that folks took. So if you are interested in like learning more, please visit the website below, undocumentedandafraid.com. Thank you. And we're going to go into another poll, our last poll. So 1 second. So please answer the poll. I'll be closing the poll in 10 seconds. 5, 4, 3, 2, 1. The polls are not closed. So thank you for that. So now we're going to share the resources available for Deferred Action. So the We All Under the Dream campaign website, it's through the United We Dream network. So they have a self-assessment tool and different information like a legal service directory, the latest news about Deferred Action, and they do have a hotline, and as well as a text messaging tool. So if you want to get the latest updates on Deferred Action, just text those OWN IT to 877-877 or UNET to 877-877. You can always check their DACA checklist as well. This will be forwarded to everybody, or it will be on a website. And the next resources we have are from Advancing Justice. So we have Deferred Action materials on this website. There's FAQs in different languages. Our toolkit will be there up soon, but I provided the link to our toolkits as well. And you can call our free help hotlines in different Asian languages. Chinese, Khmer, Korean, Thai, Vietnamese, English, Tagalog, and Spanish. So please feel free to utilize those resources. And then AKASIA, which is housed in the Korean Resource Center here in LA. they're actually having weekly clinics as well, and these are the schedules for them, and they're having one on the 15th, which is a walk-in clinic. Kind of going back to that clinic, so APOC and ALC actually provide free legal services as well. So if you just look up on those websites that I provided, you'll have more information about that. And then the National Youth Alliance, alongside with the dreamactivists.org, they made an endorsement list of like attorneys that would provide low bono fees, which is under $1,000. So if you're in one of those areas, please feel free to check the list for referral. And lastly, so a lot of LGBTQ organizations decided to put funds for LGBTQ dreamers. So it was just, the information was just released today publicly. So it will help for the application process. So they'll provide a $465 scholarships for individuals. It is limited, so it's a first come first served basis. The application will be out on the 21st, 9 p.m. Pacific time. So please jot down those websites. And I believe that's the last slide. I'm bringing it back to May for a closing remark.
All right, thank you, Anthony, and thank you everybody again for coming to our webinar. I hope that it was really helpful for you. Again, if you have any questions, there was an email address that was put out or that was shared onto the questions, and I'll just repeat it. So if you have any remaining questions, please contact info, I-N-F-O, at apalc.org, O-R-G. So if you have any more questions, please send that, and I think that is all for the webinar. Again, thank you all for coming, and we hope you have a good night.